shop in Gqeberha, and the case relates to the protection of the rights of LGBT persons, freedom of expression, and freedom of religion. We're living in a context where conservative movements are pushing back against some of the tenuous gains, I would say, that the LGBT community has gained in recent years. And so this is a really important case. It's become even more important given recent developments in other parts of the world. So I'm really interested and excited to hear about what you have to say today, Tshepo. Commissioner Tshepo Madlingozi is a distinguished legal scholar, human rights advocate. He holds a PhD in law and sociology from Birkbeck, University of London, and he's held academic positions at the University of the Witwatersrand, Erasmus University Rotterdam, and the Vienna Master of Arts in Applied Human Rights. Prior to joining the Human Rights Commission, he served as the director of the Center for Applied Legal Studies and has served on the boards of several civil society organizations, including the Khulumani Support Group and the African Coalition for Corporate Accountability. His work has consistently focused on advancing social justice, supporting the victims of apartheid, and challenging systemic racism. And we know this is not the only case that you are dealing with, Tshepo. He recently held the South African Human Rights Commission's inquiry into racial discrimination in advertising and continues to be a leading voice in the fight for equity and human dignity in South Africa. And so I don't want to say anything further. I want to hand over to you, Tshepo. So we're going to listen to your presentation. There'll be time for Q&A, and then we'll probably finish this at about just after 2, between 2 and 2:15. Okay, over to you. Thank you.
Thank you so much, Tracy. Good afternoon, colleagues. I hope you can hear me well. It's good to be back at Wits University. Of course, that's my previous employer. Tracy said former colleague, but that is slightly not true. Tracy and I are also partners in crime in another project where we are co-editing a book, a 3rd edition. We co-edited a 2nd edition, and now we are co-editing a 3rd edition. So always a pleasure to collaborate and to work with you, Tracy. So I'm going to be speaking about a specific case. This case has been ongoing for some time. The last hearing was on the 26th of May. It is within our broader mandate to uphold and to protect the rights of queer persons, broadly speaking. As you know, the mandate of the Commission is to protect, promote, and monitor human rights. Now, I joined the Commission last year in January 2024, and my focal areas, we are 7 commissioners, and because our mandate is the broadest, if you compare to other Chapter 9 institutions, we have divided ourselves into specific portfolios, focal areas. So my focal areas are equality, anti-racism, and education. Education, anti-racism, and equality. So when I came into the Commission, I, of course, looked at my portfolio, and I decided to prioritize 2 communities that, in my view, have been historically and even today continue to be oppressed, marginalized, and some would say, colonized. Of course, I receive complaints and I deal with discrimination as it pertains to all communities, but I decided that I will make 2 communities a priority for proactive interventions. And that is the Rastafari community, so-called Rastafarians, and then secondly, the LGBTQI plus queer community, broadly speaking. So those are the 2 communities that, in a proactive manner, I decided to prioritize, meaning that in addition to receiving complaints and responding to invitations, there are certain proactive measures that I will be taking in the next 2 financial years, last year and this year, on those two communities, the Rastafarian and the LGBTQI community. So I thought what would be useful is for me to, in addition to talking about this case, to also highlight in a very overview sense some of the other interventions we are doing as a commission to uphold the rights of queer communities. Now, as an office, we do not only litigate, we have a 7-pronged strategy or tactics to deal with not only interpersonal discrimination, but much more focusing on institutional discrimination and structural discrimination. As Tracy said, that has been my focus for the last 20 years since I became an academic and also an activist. You know, the two I've been doing together as a scholar activist since 2005. And I've been very much concerned about how do we dismantle the power relations that produce discrimination, institutionalized and also structural. In fact, that was one of my first articles in, when was it? I can't even remember, 2006. Yeah, 2006. One of my first articles was on institutionalized racism, you know, saying we should move away from interpersonal racism. So in the commission, we make sure that we not only monitor, but that we have certain other tactics that together they can enable us to dismantle historical oppression. Strategic litigation, number one, of course, that's what we are known for. We receive complaints, we investigate, and we either make our own findings and give recommendations. If those recommendations are not respected, we then institute litigation. We also have inquiries and hearings, policy reforms. We have recently submitted a policy reform on, you know, the use of social media, the use of AI and social media, where we are focusing on the need to regulate podcasts, because this year alone, I think I've dealt with about 4 high-profile complaints of discrimination, of harassment via social media. So we've made, you know, legislative submission on this area. We also hold dialogues. We believe in the power of dialogues. Of course, some people say dialogues are useless, you just gather and you talk, but I don't think so, colleagues. We have seen that dialogues can be a fruitful space and a platform for individuals from diverse backgrounds to come together on one specific topic, debate, talk, and really found one another towards a holistic solution. So, for example, we've held dialogues on racism in schools. In December last year, we held a dialogue on violence and discrimination in the farms in Limpopo. And that dialogue was very powerful. So we believe in the power of dialogues where, unlike hearings and litigation where affected communities cannot really talk, dialogues enable communities and affected persons to really present and talk about their lived experiences. Media provocations, very, very important, where we do a lot of op-eds. There'll be an op-ed coming out from my office today or tomorrow, a bit controversial, but that's how we like it, just to provoke public discourse. You might have seen one that I published last year on the need to move away from racial categories. Now, people say, but what kind of a decolonial scholar is this who says we must move away from racial categories? But those are some of the provocations that we make via media platforms. And of course, once you publish an op-ed, then there are interviews, and that gets a conversation going. Then diversity training. We believe very much in diversity training. I'll say more about that later on. And then, of course, because human rights are interlinked, so-called intersectional, so-called cost-cutting, we also collaborate with other focal areas in the Commission, other Chapter 9 institutions, and civil society. I will say more about our work with civil society in a minute in this area of queer rights, but Chapter 9's work very closely with the CGE, the Commission for Gender Equality. In fact, in the next couple of weeks, we will be instituting a joint inquiry. So we'll be putting our resources, and for the first time ever, 3 Chapter 9s will be holding a joint inquiry, an inquiry into how the criminal justice system deals with cases of GBV. So the Commission for Gender Equality, the Commission for the Promotion and Protection of the Rights of Cultural, Religious, and Linguistic Communities, CRL Commission, and ourselves will be pulling together our resources and doing a very powerful joint inquiry on how the criminal justice system has let down victims and complainants of gender-based violence. So those are some of the work that we're doing to dismantle discrimination. Now, I'll just mention some of the projects that we're busy with that respond to complaints around queer oppression, marginalization, as well as broader heteronormativity. We get a lot of complaints from the schooling environment, basic education level. A lot of the complaints that we receive have to do with how the codes of conduct of schools discriminate on the basis of sexuality, gender, culture, religion, and so forth. A lot of complaints. In fact, we have just concluded a report where we are looking at one such case in the Western Cape. So as a proactive measure, we have decided to come up with a model school code of conduct. A code of conduct that we will present to schools, a code of conduct that is constitutionally compliant, that is aligned with recent legislative developments, the Bella Act, the Schools Act, Children's Act, but also the latest jurisprudence. So it's a code of conduct that we say as schools, look at your code of conduct and model it after this code of conduct. So we were very happy to work with the Equal Education Law Center. So shout out to EELC, who we worked with together with about 5 experts to come up with this model code of conduct. It deals with a number of issues, including things like school uniform. You'll recall that 2 years ago, we released a report on schools' uniforms, where we found that schools' uniforms are too binary, boy, girl uniforms, and therefore don't provide space for other so-called other genders or gender diverse people or transgender individuals, learners. So we deal with that. We deal with issues of bathrooms, but also we deal with issues such as bullying. We receive a lot of complaints around bullying. So this is a proactive and a systemic intervention at the school level to deal with some of the issues that queer learners as well as other learners deal with. So that's one of the interventions that we are very proud of. We will be rolling it out to schools, where we say to schools, adopt or adapt your code of conduct. And it's not a learner's code of conduct. It's a school code of conduct, meaning that it applies to the whole school community, not just learners. So teachers, principals, security guards, coaches, sports coaches, service providers, and so forth and so forth. People who work in the kitchen for school nutrition. So it's not a learner's code of conduct. It's a school code of conduct. Very, very proud of this model code of conduct. We are also in the process of finalizing a manual, a diversity manual. So you will know that once we have found that somebody has violated PEPUDA, the prevention of Equality and the Prevention of Unfair Discrimination Act, or the Constitution, Section 9, we normally ask for certain remedies. One of them will be that the individual must undergo a sensitivity training. But we normally outsource such training. So for the first time, we are creating a manual where we ourselves as a commission will be, training those individuals. And here again, we work with a university, the UCT, Office of Inclusivity and Change, under Dr. Shine Alves. So shout out to UCT, one of the very proud collaboration that we have. I must say that with VETS, we also have a lovely collaboration under Tracy on Water Justice Tracker. So we work with universities to extend our work, but also to help us. So this manual focuses on key areas, including unconscious bias. But in the first place, this training will also be towards our staff members, all 198 of our staff members. I have been at the commission for almost 2 years now, and I've never received a sensitivity training. So we ourselves as commissioners, as staff members, as security guards, as general workers, we are not fit for purpose because we have not undergone this sensitivity training. So it is for people who are found by the courts or ourselves to have violated PEPUDA, but it's also for internal purposes. But we've also been asked by universities, by schools, by workplaces to do this kind of training. So this manual is also very, very important for this. We focus a lot on the concept of critical diversity, not just diversity, not just inclusion, which ends up being about assimilation, but about critical diversity that attends to the power relations, the ontology of structures, the institutional culture, where you don't just include people in very messed up institution, but critical diversity where the whole structure changes. So we are also very proud of this intervention. We worked with a committee of experts who assisted us to craft this manual. You might see some of the people that you know, Advocate Florodolo, some of you might know Advocate Florodolo, who is also a part-time counsel at CARS. And other people there who have really helped us to craft. So this is a committee of experts that help us to do this. But this year, we also launched a 6-year program, which my office will be running for 6 years, which focuses on the national question, where as an office, my office, we are saying the commission has been in existence for 30 years. So we are using this anniversary year to look back and to look forward. In addition to attending to individual complaints, 7,000 of them per year, what has been our contribution towards resolving the national question? Or put differently, what has been our contribution towards promoting a culture of human rights as per our mandate? We propose that there's no way you can promote a culture of human rights without resolving the national question. The question about how do you forge a nation from the wounds of settler colonization? What are the values of the new nation? How do we forge a social compact? Because without a social compact, there is no framework for social justice. But more critically, how do we forge a society where everyone has a sense of belonging, and belonging from two perspectives: affective belonging, a feeling that I belong to this country, this polity, but also material belongingness, because it's not enough for you to feel that you belong, but materially, how do you share in the resources of this country? So we are very, very proud of this campaign, which focuses on what we regard as the root cause of xenophobia, homophobia, ableism, homophobia, racism, patriarchy, and so forth. The failure to resolve the national question. And of course, when you talk to a lot of queer individuals, there's a sense where people say, we don't feel a sense of belonging. We feel like pariahs in the new South Africa. So this question of belonging and the national question, colleagues, is not simply a question of race, but it's a question about how do we forge a society of universal belongingness. And coincidentally, this project that we started last year has become very important with what we are seeing, where people are scapegoating non-nationals, people are scapegoating people from other ethnic groups, minority ethnic groups, and so forth. Belongingness and the national question is at the core of promoting human rights. And here, once again, I worked with a committee of experts from academia, from business, from civil society, who helped us to conceptualize this project. So you can see people like Christy van der Westhuizen, people like Zuleka Patel, your former colleague, Dr. Salele Sibanda, Chamika, who's at VETS, and other people who have helped me to conceptualize this program. The other intervention that we are focusing on is on intersex rights, intersex. Because of course, within the broader family of LGBTQI+, there are also other people who are also further marginalized. And we get a lot of complaints to do with intersex persons and their lived experiences. So we have decided as one of the interventions to publicize a pamphlet on intersex children. So this pamphlet, which we have finalized and will be rolling it out in public health facilities, is a guide to parents of babies who are born intersex. Number one, educating them what is intersex, educating them on the dangers of intersex genital mutilation, educating them on consent, proper consent when doctors, nurses, and other people put so much pressure on them to, consent to irreversible medical procedures or surgeries or operations. So it is to say to parents, this is what intersex is about. These are your options. These are the best interests of the child. Do make your own decisions if you want to consent to operations, but these are the options. So we are also very proud of this pamphlet, which is part of our promotional framework, a pamphlet on intersex children. As I said, we deal with a lot of cases where intersex persons come and after a few years, when they become adults, want to sue their parents, or people live with lifelong scars because of irreversible procedures. So as part of our promotional work, in addition to litigation, in addition to other interventions on intersex persons, this pamphlet that goes to parents is very important. And as I said, we'll be collaborating with the Department of Health to roll out this pamphlet, but also to use that opportunity as education for other people. Then, of course, equality court cases. We are before the equality court on a number of matters to do with queer rights. Some of them have to do with transgender people. There's also a case that I will talk about later, or maybe let me talk about it now. It's about racial discrimination. But it goes to the core of what we'll be talking about today. So this case of Naidu, who is a complainant, Miss Naidu is a complainant in the Free State, where a WhatsApp was sent to a group where, in our view, the statements that were made about Indian persons, people of Indian origin, amounted to hate speech and harassment. And the court found in our favor. The court found, number one, that publicizing or sending that WhatsApp message in a group amounted to publication. And then secondly, that the words that we use about Indian people amounted to harassment and hate speech. You will see why this case is important for the case that I will be talking about. Naidu, the respondent has appealed, and we will be opposing the appeal on this matter. Matters or messages that are disseminated via WhatsApp groups, we deem them to be publication. We deem administrators to be responsible, and we don't accept the defense of privacy. The other intervention, of course, that you know about has to do with Caster Semenya. The case was not in South Africa. The case was in Europe before the European Court of Human Rights. We intervened as a third-party intervener. We were granted permission to intervene as a so-called amicus, where we were very clear to court, number one, that sports companies cannot rely on the fact that there was an agreement between themselves and sports people to violate human rights. Number two, where we are bringing forth jurisprudence from the South African Constitutional Court to do with intersectionality, that Caster is not just discriminated as a sports person, but also the issues of sexuality, issues of race, but also issues to do with the global south and the global north, the global apartheid, or if you want to be fancy, the global matrix of coloniality. This case was very important for us, not only to intervene to assist Caster, but pedagogically it helped us to also educate the public in South Africa on some of these issues. So even though it's in Europe and it's assisting Caster and similarly placed people, every time we go to court, interviews, op-eds, we also used it pedagogically to intervene on similar issues in South Africa. So we were happy when Caster Semenya won, and this morning I had a meeting where we were talking about how do we take these matters further. Now, the last thing that I want to talk about before I focus on the case is that as a commission, or as my office, we accept that we have not done enough on issues to do with queer rights or LGBTQI plus rights. We have not done enough, and therefore we will be setting up a committee of experts that will advise me and the commission on where to intervene, what are some of the key issues, and how we should be intervening. So Section 11 of our Act, of the South African Human Rights Act, enables us to appoint a committee of experts. So we will be creating this committee that will serve as an external advisory committee to advise me on some of these issues. It's not there yet, but we'll be setting it up. I must say also that you will have seen that we've been dealing with a number of hate speech cases where, as a commission, we want to create not a jurisprudence, but a consensus in the country about what constitutes hate speech, what is acceptable language, what is not acceptable, what politicians can say and not say. Therefore, we've been very proactive in taking up a number of cases. So you'd have seen that this year, my office, but also the commission, we have dealt with matters to do with Mr. Ronaldo Gous, the former DA MP. We have dealt with the Open Chat podcast, where there was hate speech against colored people. We have dealt with the case to do with Mr. Notaboloi, where there was hate speech against white people. We are taking Minister McKenzie to court for hate speech. And you have also seen that recently we were successful in the matter to do with Mr. Malema for incitement of violence. So as a commission, in addition to receiving complaints, we are proactively trying to curb what has become a culture where you can say anything homophobic in the name of shock, in the name of clickbait, in the name of getting more followers. Unacceptable. Unacceptable. It's therefore really an attempt to get a clear consensus on freedom of expression within limits. Within limits. We are also very concerned with disinformation, very, very much concerned about disinformation. As a commission, we are victims of disinformation. You'd have seen that myself. I'm a victim of disinformation for taking on some of these issues. So, but disinformation, colleagues, is much more egregious when it pertains to historically oppressed individuals. Disinformation is a major threat to democracy, and all of us must do our best to curb disinformation. Yesterday, we had a lovely seminar on hate crimes. As a commission, we are saying that it's not enough that we achieve so much success before the Equality Court or via mediation, as my office has been doing this year with a lot of people, where through mediation and settlement, we get the same results that we could have gotten in court. But we are saying that hate or crime that is committed on the basis of homophobia, xenophobia, ableism, sexism, racism, etc., must be classified as hate crime. Of course, the act is there, but as a commission, we are very much concerned that the act has not yet come into force. So yesterday, we had a seminar with colleagues from gender dynamics, colleagues from SAPS, South African Police Force, and others, South African Police Services, and others, where we're dealing with hate crime. So as part of our intervention, we will be putting pressure on the executive to finalize and to make sure that the Hate Crimes Act comes into force. Lagardien. As Tracy said, this is a case that is in the Eastern Cape, in Gqeberha, where a sign was put outside a shop, a private establishment, not a private establishment, but a shop. And the sign said LGBTIQ, not welcome at Lagardien, save our children. That was the sign. Furthermore, a WhatsApp group was created, we allege, by the owner of this shop, and the group's name was called Our Rights Anti-LGBTQ+. We looked at this matter and we came to the conclusion that prima facie this constitutes a violation of PEPUDA under a number of sections to do with hate speech, to do with harassment, to do with incitement. So we sent an allegation letter, and then after that we instituted proceedings before the Equality Court. I'll present our case, and then I'll present Mr. Lagardien's case. As I said, the case was last heard on the 26th of May, and we look forward to the decision of the court. Our case is that, as I said, the sign, the WhatsApp group, and the content of the WhatsApp group very clearly amount to hate speech against LGBTQI persons. Two, that the sign constitutes harassment in terms of PEPUDA, and that the content of the WhatsApp group, the message is there, taken all together, a reasonable person will apprehend this as incitement to violence, catch this evil vermin, for example. As you know, the court has found that animalization of individuals is hate speech, calling people baboons, dogs, and so forth. Cockroaches, the latest case against Mr. Kedukunene vis-a-vis Mr. Malema. Catch these evil people. We took the view that this amounts to incitement to violence and that the sign is harassment. So, as I said, our argument is that the right to freedom of religion, the right to freedom of expression are not unlimited. They are not unlimited, colleagues. What we seek from the court are a number of things. Number one, as we always do in all cases where we go before the Equality Court, first of all, a clear declaration by the court to find that Mr. Lagardien, the sign as well as the WhatsApp group amounted to hate speech, incitement, and harassment. We want that finding. We want an interdict where the respondent will not commit similar quote-unquote offenses in future. A unconditional apology, public apology, and we normally say that apology must be drafted together with the commission so that it's unconditional, so that it's very clear. You know, in media interviews, people always ask me, how do you know that the apology is sincere? I don't care whether it's sincere or not. No one can know whether an apology is sincere. What is important is that the apology must, number one, be unconditional. Number two, the apology must take accountability. No manga. Very clear accountability and acceptance of the harm that was done. And then number three, and clear undertaking not to do this in the future. Sincerity, you know, we leave that to the faith-based community. But we are interested in unconditionality, acceptance of accountability, and an undertaking not to do this in future. In this case, we are also asking for $500,000 in damages to be paid to a charity that the commission will select. So that's our case, and that's what we are looking for from the court. To be fair, let me present the case from the other side. In a nutshell, the respondent is arguing that they've got the right to freedom of religion and conscience and belief, and that in their religion, LGBTQI or queer or homosexuality is un-Islamic and amoral, and they are allowed to hold that position and to express that position. They argue that the sign as well as the WhatsApp flowing from the right to freedom of religion are permissible forms of expression, that they are allowed to hold this opinion and to express this opinion, and that they put up the sign after a sexually inappropriate conduct in their shop, and they also claim that they were victim of threats from the LGBTQI community, and therefore they created the WhatsApp group to warn other people about this community and the threats that they're facing. So that is their response. They also claim that we cannot prove that they created the WhatsApp group. Alternatively, that the messages in the group do not meet the threshold of hate speech and harassment, but that they are expression. As I said, that is what they say. We hold a different opinion, and we hold very steadfastly that colleagues, the right to freedom of religion, the right to freedom of expression are limited. Furthermore, if you go back to what I said about why proactively my office decided to prioritize this community, when it comes to certain communities, we know that certain words and acts have been said and that have led to physical violence, marginalization, and broader invisibility. So this case, we take it as a very important case, a case that will clearly set out the limitation of the right to freedom of expression, limitation as far as the right to freedom of religion, but also, these perennial questions about my shop, my rules. We don't accept that. We don't accept that for public establishment that, are geared towards the public. I must say that we've got a lot of other cases. You'll remember our case with Mr. John Kolani, where eventually the Constitutional Court amended the PEPUDA, but the Commission also took up that case. We are also in court in Gauteng against a very prominent politician for statements that they made on Facebook against the queer community. We are also in court against a teacher who on TikTok also made very homophobic statements in our view. We are also in court where the use of the word M for mother, M for Madlingozi, the M word when referring to, no, in fact I'm lying, the use of the word S in isiZulu and in Sesotho to refer to queer people, S as in sugar. Those of you who are isiZulu, those of you who are Sotho, those of you who are from the township, you know which word I'm talking about. S for sugar. That term, we want the court to find that term is homophobic. So, colleagues, that is some of the things that we're doing. The last thing that I will say is that, when the court said on the 26th of May, we were heartened to see, we didn't even know that this was going to happen, where a number of civil society groups created this poster. As I said, we had nothing to do with this poster, but the poster that said will engage with a solidarity march towards the court in support of the Human Rights Commission, but most importantly in defense of the Constitution. Very important because we receive a lot of threats. After this seminar, the Commission is going to receive complaints. After this seminar, I'm going to receive complaints and disinformation campaigns. So I want to end on that note to say we appreciate the support, the solidarity that we get from civil society and other people. I don't know what's the time. Let me end there. Thank you so much, colleagues.
Thank you so much, Tshepo. That was fantastic. Colleagues, we have time for, I think, a couple of rounds of questions. So if you would like to ask a question, you can please raise your hand now and ask it. Alternatively, if you'd rather put that question in the chat, I can read it out. Yeah, so questions for Tshepo. Thomas is first. Thomas, please go ahead while other people decide to put their hands up.
Thanks so much. And also, thank you, Tshepo, for a very interesting presentation. And also, speaking as a queer person, I'd like to express gratitude to the Commission for doing this work. It's really important work. So I wanted to ask you, I think you touched on it towards the end. I wanted to ask you really about, I guess, the associational rights that someone like Lagardien might raise, or that, say, churches in the past, right, have raised. I was wondering if you go into a bit more. You said that this is a shop that serves the public, right, and that therefore, I guess that there's a higher standard that's expected there. And I was wondering if you could go into that. And I'm wondering about that because, the argument that has been raised, certainly in relation to churches, is that constitutionally it would be permissible for a church to discriminate, or a religious organization to discriminate, if against a particular person, if, for example, they were involved in the preaching of church doctrine, right? And there's wide discretion given to the beliefs that the religious organization may hold, right? And certainly it seems like a court is very weary about, I guess, essentially treading on those beliefs. But there seems to, differentiation seems to be made between someone who is, say, preaching a particular doctrine versus, say, let's say, like a janitor or a cook or an administrative person who's employed, right? And is not necessarily involved in sort of preaching the church doctrine. And there it would seem that discrimination, if there was discrimination there, that would be unacceptable. So I was wondering if you could maybe speak about that kind of associational argument in light of the Lagardien case. I guess maybe an argument that he would position is that it is, sure, I might serve the public, but it is a private business, and therefore I should be able to essentially have, I guess, the right of admission. And I'm wondering if you can talk constitutionally about why that is a poor argument.
Wonderful. Thank you, Thomas. Before you answer, Tshepo, I've got Elsha's hand up as well. Let's do 2 questions at once. Elsha, floor is yours.
Hi, everyone. Thanks, Tshepo, for this. It's very interesting. I'm just wondering, you mentioned the rights of trans people. Can you tell us about the work that you are doing also in relation to trans people, whether you're intervening or bringing any cases on their behalf? Yeah, thanks.
Please go ahead and answer, Tshepo.
Thank you so much, LJ and Thomas. And when Thomas, I see you on the street, I say hi, and you don't see me. I'll get you next time.
Sorry.
Associational rights. No, I mean, yeah, right of admission reserved. As a Black person, I've suffered because of this, where I've been subject to racial profiling and racial discrimination. And people say, but, rights of admission reserved. We had dealt with those cases in South Africa, but also internationally. You'll recall that there was a case of a wedding venue where someone said, for my wedding venue, I don't allow, same-sex marriages. And the court found that, yes, we have to respect your right, but when you are carrying out a public business like that, not a public business, sorry, colleagues, not in a sense of public law, you know what I mean, but a publicly facing business, you can't rely on that, because if you do that, as I said, I'm giving you my example, people who discriminate, we will allow public discrimination all the time because of, this is my space. It's not a home, it's not a house. That's a different story. So we really want to argue that, number one, as South African, given our history, but given the fact that there are people who continue to suffer from marginalization, oppression, and invisibilization, that kind of argument would not hold. You are quite right. We dealt with such a case in the Western Cape where a preacher was discriminated. That case is still within the court, where he said, discriminated. No, in fact, he was not a preacher. He was a music teacher at that church. And they sought to say, but that's our worker, doctrine, and so forth. we argue that this person is not a preacher in your church, for example, So we will want to distinguish, as you have done, those two. But also you will know that after the death of Imam Hendricks, in the same area, by the way, in Gqeberha, by the way, yeah, there were people who wanted to justify this on the basis of doctrine and scripture. And there were people who were saying, but the scripture does not say this. So even within faith-based communities, there are contestations. I'm not one to talk about that, but just to say that, it is not enough for me to say my Bible says the following, my Torah says the following, because there are a lot of contestation within that. If you go online now, you will see that there are a lot of queer Muslim individuals who are, coming out and contradicting some of these things. So that's not for us to talk about. But yes, this case, as I said, has to do with harassment of individual people. I mean, the use of the word save our children carries a lot of implications, which all of us know what that implication is. So I will say, yes, associational rights are very important. Paradoxically, as South Africans, we have been denied this right of association, so we must be careful. But the Constitution is very clear. Our fundamental values of dignity, equality, open society, very, very important. Very, very important. And then on trans rights, there's been a lot of developments to do with transitioning, but we still have a lot of complaints to do, number one, with gender affirming healthcare. Number one. Number two, even on the issue of transitioning, we get a lot of complaints, and we agree that if you look at the present policy, it pathologizes in a sense that you must go to a psychologist who must prove. Now, why must you go to a psychologist? And so there's a certain pathologization, but also it can be expensive to get those psychiatric or psychological assessments. So gender affirming healthcare. And thirdly, we have issues to do with our ID documents. Those three last numbers continue to be a problem. And then number four, there are doctors who have taken it upon themselves to be advocates of anti-trans rights, who go around schools, who go around communities saying, transgender individuals are suffering from a certain pathology, and that there's nothing like transgender individuals, but these people need to be helped. So we have some doctors who, in our view, consciously seek to oppress transgender rights. So we've got those issues. We've got issues in the workplace where, things like uniforms, but also general harassment that also even go to issues of equal pay, implicated. Equal pay, but also general harassment, people using words and normalized transphobic jokes in the workplace. So as a country, we've done a lot to move forward in this area, but there are still some issues that we are dealing with. Thank you.
Wonderful, thank you. Are there any other questions, burning questions that you'd want to ask? This is your moment.
No, I was very clear.
I'm not seeing any more hands. Okay, Tshepo, you are absolutely right. We are colleagues. We have this book project between us at the moment. I really want to thank you for today. I think it's been a fantastic webinar. It was really good to understand the broader context and all the levers of change that you are driving at the Human Rights Commission. And there's something really beautiful about seeing somebody in the right place. We're very glad that you're in this right place, Tshepo. Amazing work that you're doing. For me, what I'm taking away from this particular webinar is this idea of critical diversity and the vision of universal belonging, which, you know, it's so right there, given what is happening in the world. It's so important that we hold this vision because it's a beautiful vision. It's a big, beautiful vision, guys. And that we are going to be able to reflect the gaze. You know, or just what you were saying about this this principle of animalization of people as a form of hate speech. I think it's a very useful and anchor when one is looking at this debate about what is the scope of free speech and how do we temper it? How do we create a society of universal belonging? So I'm very grateful that you spent the time with us today. We've been enlightened, we've been enriched by your presentation and by the questions. Thank you again. Have
Thank you so much, colleagues. Thank you so
a
much.
good
Thank you for
Tuesday
letting me.
further, guys.
Right.
Thank you. Bye-bye.
Bye.
Thomas has got a last minute hand. Thomas.